Patricia Weaver. Thank you.
Good afternoon. Thank you for the opportunity to be here today. Because I do have a current existing case in the state of Connecticut, I chose not to talk about the details of my case. Rather, I had met with my local state representative, Christine Conley, at a local town meeting, and she was seeking a legislation how to improve the Connecticut court system. And when I proposed the idea, since she herself is a lawyer and had to deal with the Connecticut court system, she thought that my idea was a good one. So while I had seen the advertisements for this public hearing today, I was really worried about potentially coming because of my ongoing case, but Christine Conley's assistant reached out to me and said that it would be a good opportunity to come here and speak today. So my recommendation to improve relations and confidence in the judiciary is by changing the mechanisms in which the family court and the criminal court communicate. As you know, there has been an increase in family domestic violence cases and associated family homicides rates across the United States. Currently, there are separate judicial websites in Connecticut, one for family and one for criminal. I would propose that these separate judicial websites be linked as followed. If a party is arrested in a criminal court domestic violence matter that is also a party in an existing civil case, that the family file would be automatically flagged. As soon as the arrest for domestic violence is made as part of the criminal process, the relevant public information should be made readily available to other organizations such as DCF, Safe Futures, 211, and Family Services to assist both parents and children in getting the necessary referral and counseling assistance. Any related unredacted police reports created during the arrest should automatically be issued to the presiding courts and victim advocate group to alleviate the he said, she said accounts whilst awaiting and be on hand for the first court appearance. Victims shouldn't be required to subpoena records to protect the best interest of themselves and or their children. Individuals directly involved in the incident thereby have copies of this essential documentation. Currently, if there is a restraining order file, it is docketed as a separate number. The restraining order file should be permanently linked to the main civil family case as a separate addendum and accessible on the website to the presiding family court judge, and should be taken, and he should take automatic notice and consideration when making future custody decisions or memorandums of decisions, even if the charges are nullied. Any crimes against children should remain flagged in the family file until the child reaches the age of majority. Sorry.
Take your time. You're gonna be all right. You got this.
It is an imperative that the family judge has all the available relevant information in front of him or her when making parental fitness determinations in accordance with the best interest of the children standard and future motions to modify custody. The current understanding is that the restraining order file disappears when the party has complied with the JDNO orders to attend an anger management and or family violence program and the charges become nullied. In a high conflict case, just because the charges have been nullied doesn't mean that the offense wasn't perpetrated by an act of free will at the time. These individual character attributes do not automatically disappear and remain, which contributes to the ongoing family dynamics. There needs to be a safeguard for families with a history of domestic violence, that if any individual psychological evaluations, family psychological evaluations, DCF or family service investigations are court-ordered, that the person charged with the prior offense be mandated to disclose this information to the expert, even if the charges have been nullied. This full disclosure would allow the expert to make a fully informed, impartial decision associated recommendations for the individual and family. Currently, they are entirely separate judicial websites, and the evidence must be brought into either court case. The safety and well-being of our children and our families must be protected by linking these websites together in a simple way, and which is a simple way to ensure that all relevant court proceedings are known to the court at the time when they are making decisions.
Any questions?
I also had one other suggestion, if I may.
Yes. Yes.
My other suggestion to the judiciary would be to modify the parent education program, which is antiquated and ineffective. The parent education program is ordered when tensions and frustrations are high between the parties as families are transitioning from living together to living apart. Parents are currently simply required to register for the program, pay a fee, attend a program, most times not together. They listen to a vast amount of material in a very compressed time period in a lecture group format in order to receive a pink slip as proof of compliance. But how effective is it? What did the parties digest in the current format? My proposal would be to expand the current parent education program as follows. Couples, upon filing for divorce and seeking interim orders during the mandatory waiting period, would be required to attend court-mandated weekly co-parenting family therapy together for 3 months. The object of this therapy would be to learn how to adapt and adjust through this tremendous situational family life change. Couples would also be required to sign up for myfamilywizard.com, which has the ability to be monitored by third parties such as lawyers and therapists. Every entry made is date and time stamped. This formal written communication would be utilized to share information between the parties regarding the children's medical, educational, religious, social appointments and schedules. This gives the capacity for both parties to know what is going on in their child's life. Co-parenting counseling would encourage parents to mediate, compromise, and deviate, as well as recognize how their daily choices and interactions impact each child differently. Children are like sponges and absorb much more than adults realize. The children didn't make the choice to have their family divided. Parents are role modeling adult interactions and behaviors. A divorce can fracture a child's well-being at any stage of emotional and intellectual development. Childhood is fleeting. Children need structure, routine, and continuity to feel safe and secure in their environment. Family bonds should be strengthened, not broken. Family lawyers should emphasize the importance of joint decision-making through effective co-parenting and mediation rather than discouraging communication, which further fractures the situation. Neither party comes into the court process fully realizing how life-altering this decision is until they've invited a myriad of strangers into their life. It ends up literally draining them mentally, emotionally, and financially. After parents are accustomed to seeing their child every day, having liberal access and to partial access, it is one of the most heartbreaking, heart-wrenching realizations in the divorce process. These changes place the emphasis on parents to be held accountable and responsible for their own interactions while having a counselor as a third party to effectively mediate issues in a safe environment. In high-conflict court cases, the court could have the capacity to extend the mandatory co-parenting family therapy and the My Family Wizard utilization. If one party refuses to participate in the court-mandated process to improve communication in the best interest of their children, they could be found in contempt. This proposed change would ensure that parties have viable resources to improve their co-parenting and communication skills from the onset of the divorce process, which would reduce the financial and emotional impact on the court and families, making the process less futile and less expensive for everyone involved.
Well, thank you for coming. Do you have any case pending?
I do, but I would prefer not to talk about it.
Okay. I understand maybe why you shake it and why you like that.
So I will say that I believe parents, when we become parents, parenting does not come with a handbook. However, what parents bring to their table, their children's table, is their life experience and what they've learned from it. Some of us have gone through exhausting, debilitating life things. Some people choose to take roads and they don't make good choices and decisions in the best interest of their children. Sometimes life hands you lemons, but you make lemonade, and you get the help that you need to be a better parent for your child. And you learn by, just because your parents made poor choices and decisions, that it is within your right and the gift of each new day to become a better person, not only for yourself, but for your child.
Thank you very much. Thank you.